Prosecutorial discretion is back. The Remain in Mexico policy has ended. Cases have been reopened. The reopening of cases in deportation in removal proceedings based on the 9th Circuit Court decision, and the current state of our bills. In this video, I'll talk about the latest in immigration news. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area. If you're new to my channel, please go ahead and subscribe. If you're not new, welcome back. Thank you for subscribing, and please don't forget to hit the notification bell so you don't miss any of my videos. If you enjoy the content, go ahead and like, share, and don't forget to comment below. Let's get right into it. Let's start with the first one, the biggest one. It is that prosecutorial discretion is back. Okay, what is it? Discretion to choose, that the government has to choose whether to punish or not, whether to prosecute a case or not. Basically, now ICE will have more power, discretionary power, to decide what cases to drop. Basically, what cases to settle outside of immigration court, which is really good, because remember that ICE has limited resources. They have to focus and prioritize on deporting criminal with serious crimes only. You know what I mean? And under Trump, what we saw is that everybody was being brought into removal proceedings just because they were charged with some deportable offenses. But now under Biden is giving more discretion, that power is back. It has been there, but not in use under Trump, because he stopped that. But now Biden is giving that power back, the power to decide whether they should prosecute a case or not, whether they should drop just altogether or settle the case outside of immigration court. Who is qualified? Are you qualified? Let's see who's qualified. It's talking about they will drop, okay? ICE prosecutors allows the agency lawyers to drop cases against green card holders and those who are elderly, pregnant women, people who have serious health conditions, or people who have been in the U.S. from an early age. Furthermore, an argument can be made in terms of whether the lawyer could bring up compelling humanitarian factors. Those are mitigating factors when it comes to the decision whether this case should be dropped or not. And whether the defendant, so the non-citizen, whether the person is a caregiver or a victim of a crime. Let's go with specifics when it comes to those type of issues. For example, let's say somebody, when they talk about green card holders, let's say somebody had a green card, the person became a green card holder, and now the person has found themselves in removal proceeding. Why? Because they have been charged with a deportable offense. For example, a person can be charged with obtaining green card by fraudulent means, okay? And now the person who was a lawful permanent resident, their green card is at stake. Now they're in removal proceedings. What's going to happen with this prosecutorial discretion is that the government will have a choice whether to just pursue this case or not. And when they look at other mitigating elements or factors, humanitarian factors, whether that person now in removal proceeding is an elderly, whether that person is a pregnant woman, whether that person is basically a caregiver or a victim of a crime, at that point, the ICE or the government will choose whether they will prosecute this person or not. They will pretty much drop that case. That's what it means by prosecutorial discretion, okay? That's just one example. You don't have to be a green card holder to find yourself in removal proceedings. There are other people who are non-U.S. citizens and they are in removal proceedings based on a deportable offense. Maybe the asylum did not work out the way they thought it would, and now the person is finding themselves in removal proceedings. But now, if the person meets those type of requirements, they can in fact ask the lawyer to make an argument so that ICE can use their discretionary power to drop the case if the person in fact is whether a caregiver or a victim of a crime or an elderly, or the person has serious health condition, or the person came here at an early age. We have people who have been here for 40 years, 45 years, and find themselves later in removal proceedings. If the person came when they were 6, 7, why should that person leave now? It just don't make sense, because they have been accustomed to this culture, to this environment. This is pretty much home to them. So this thing is very good. You must, if you feel like you qualify, must check with your lawyer, or if you don't have one, you can also call our office to 2751-2180. Email on display. Consultation fees apply as usual. That's number one with that news. Let's talk about this very good one again. This one is so good. This is about the departure bar, okay? Reopening cases in removal proceedings. Let's say the case was closed, the person has been ordered removed. Can you in fact open the case? The old law, when it comes to the departure bar, the old law says that, let me read you what the old law says, okay? The departure bar regulation states a motion to reopen or to reconsider shall not be made by or on behalf of a person subsequent to his or departure from the United States. So that was the ruling in 1995, okay, by the BIA, the Board of Immigration Appeal. But the thing is, pretty much, it's in simple terms, it means that if a person has been ordered removed and later on the person leave, either voluntarily or because of the removal proceeding has come to the end, the person has departed, right? That person is barred from reopening their case. That's what that rule said. They cannot make a motion to reopen the case because the person has left the country and the person has chosen to voluntarily leave the country after the removal, after being ordered removed, right? They cannot come back and ask the judge to reopen the case, basically file a motion to reopen. That was 1995 ruling. But now the 9th Circuit Court has ruled differently. The 9th Circuit Court has ruled differently. It says that, of course, we are not going to take a motion to reopen or to reconsider based on this departure bar, but the judge on its own, his own, that's what they call sua ponte, on the judge on his own decision can in fact reopen a case if the defendant asks him to do so. So pretty much that's the new ruling. What does it mean for you? Let's go with this specific example. This is a person who came in the United States in 1995, okay? The person came in the United States in 1995, and then later on, he was pretty much ordered removed, right? And later on, he unlawfully re-entered the country, like just a couple months later. And then since then, the person went ahead and tried to reopen the case. He has been living in the US after just being removed, and he entered illegally and basically without permission. And stay in the US. And now the person asked the judge in 2016 for the judge to reopen the case, motion to reopen. The person files a motion to reopen so that the judge can reopen the case, so that he can adjust status based on an application that was previously filed by his father. So basically, adjustment of status from a relative. Okay? And the judge said that because of the departure bar, we cannot reopen the case. And the person did not end there. The person went all the way on appeal, and the same ruling on appeal, and then the person went to federal court. That's when the person went on the 9th Circuit Court. And then the person has, finally, the 9th Circuit Court has said, the court joined the 10th Circuit, okay, in holding that the departure bar does not limit immigration judges' sua sponte authority to reopen cases. What does it mean? It simply means that the judge on his own accord can in fact reopen a case. That's it. That's what it means. Motion to reopen must be addressed to the judge directly, and the judge, if the judge wants, the judge can reopen the case. Basically, they are not going back to the old rule that said that once you have departed or voluntarily leave the country, you cannot file a motion to reopen and reconsider. But now they're saying that you can in fact ask a judge to reopen, not based on your motion to reopen or reconsider, but based on the fact that the judge on his own can in fact reopen a case. So that's the difference. If you don't understand it in those simple words, it means that you need a consultation, okay? So consultation number is 202-751-2180, and consultation fees apply as usual. And we can see if we can in fact reopen your case so that you can adjust status. Basically, if something has happened lately, like your child is now a US citizen, 21 years old, and the child can in fact apply for you, but because of your departure, you couldn't reopen a case. But now, I believe you can ask the judge. If the judge wants, sua ponte, they can reopen the case for you. So basically, that's the new ruling, 9th Circuit Court, and this becomes the new precedent, and that's the one we will go with moving forward, okay? So if you really need the explanation, then you must pay for consultation, pretty much so. Let's move on to the third news. This is good again. This is really good. Remain in Mexico, MPP, has ended officially last Tuesday. Remember when I was talking earlier on, I guess in March or February, we were talking about this Remain in Mexico policy, and we talked about it in a way that was very understandable. What it was a program implemented under Trump that required people seeking asylum from the border of the country to remain in Mexico until the asylum case gets adjudicated, okay? That was that policy. Trump wanted people to be outside until the judge decides whether the asylum is valid or not. And then at that point, the person can get inside. And then when Biden got elected, January 20th, we came here and we said that he made a pause on that policy, and he said to those people to remain there until further notice. And we didn't know when was that further notice was going to take place. But last Tuesday, the policy has officially ended. What it means for a person who is in Mexico, it means that the person can in fact get here and wait for the asylum case inside of the US. If you're coming from the border, those borderline countries, if you're coming from those borderline countries, basically you can get here. And if you were remaining in Mexico from that time being, you can still get here and wait for your asylum case adjudication inside of the United States. And this is a great news because at least we're going back to the old rule that asking for asylum at the border is still legal. You can ask for asylum at the border of the country and get in the country and wait for your case to be adjudicated. So we went back to the last policy, and this is really good. So basically, the administration must follow through on this announcement by ensuring that everyone who has been subject to this policy can now pursue their asylum case in the United States in safety and without additional trauma or delay. And it must swiftly move to dismantle the Trump administration other attack on asylum system, including unconscionable Title 42 order. So basically, the law is that you can in fact ask for asylum inside of the U.S. when you're coming from the border, and if you were under that policy, remain in Mexico policy, you can in fact leave Mexico and get here to wait for your asylum case to be adjudicated. And this is a great news for most families coming from the southern. Okay, and the last great news is this. This is partially good, but it is good. What is happening with the state of our bills? The state of our bill is in the hands of the budget reconciliation, and we know that they tried to come up with a solution, at least partially. In April, it didn't work out, but in September, when they are voting for the new budget, okay, fiscal year end, another fiscal year start, voting for a new budget reconciliation, and infrastructure bill, where they're gonna see how they're gonna spend on what and on what. The parliamentarian, because remember, we're trying to see whether they are going to allow those Democrats to bring in those immigration bills under reconciliation. The parliamentarian has said that they might in fact allow at least one bill for this year. So now the question is, which one will be allowed under this reconciliation, budget reconciliation, or under this infrastructure bill that will set the spending for it in September? Which one? I do not know. But I'm thinking maybe it's going to be these essential workers, or maybe it's going to be TPS or Dreamers. We don't know. We don't know for sure. But what I'll suggest strongly is for you to follow Chuck Schumer, the majority's leader from the Democratic Party. He's the one who's behind the scene trying to see what he can do, what he can come up. Some people have called him out about it because they say like he's trying to sneak his way to give undocumented people status. But he's working hard, and he's someone to support basically, because he's working hard and trying to see at least put one immigration bill to this budget reconciliation this year. So we're hoping, and finger crossed, let's wait until fall, because right now they're in summer. After these 3 weeks, they go in recess and come back in September. And that's when they'll be talking about the budget reconciliation and pretty much the infrastructure bill, the big one. So that's when we will know something, but at least we have a hint. That's it. So this is it for today. We had 4 great news. My friend, you need to share this video like never before, because people have been remaining in Mexico instead of waiting for their asylum here. And remember, if they applied long time ago, they should have their work permit already in process. So by the time they get here, they will actually apply for the work permit and actually get the work permit. You know, this remain in Mexico policy has really dismantled a lot of people. And now some people might in fact reopen their cases, and discretionary measure when it comes to prosecutorial discretion is back. My friend, what else to hope for? This is great news. Bijoux.ngwanda here, immigration lawyer in the DC metropolitan area, and this was US Immigration. Until next time, bye-bye.